Good day, ladies and gentlemen. Welcome back to another What If video. In today's video, I will be unpacking a scenario where an employee resigns, but then later withdraws the resignation. Now, the question is it possible for an employee to withdraw a resignation? Now, to answer this question, I will be referring to the matter involving an employee and the Dr. J.S. Moroka municipality. The facts of the matter are very interesting, and briefly it is as follows. On 1 April 2021, the employee tendered his resignation with immediate effect due to ill health. The resignation letter was addressed to the administrator of the municipality, as the municipality back then was under administration. On 15 April, 2 weeks later, the employee then sought to withdraw the resignation, and he awaited the acceptance of his withdrawal in order for him to resume his duties on 19 April. On the same day he attempted to withdraw his resignation, the administrator responded to him and informed him that his withdrawal is not accepted and that he should not report for duty on 19 April 2021. The employee said he never received that email from the administrator on the 15th of April. In fact, he said only on the 23rd of April was he made aware, or did he notice the email from the administrator. So he reported for duty as normal on the 19th of April, and there was no objection from the administrator in that regard. On 25 April, which is the usual payday at the municipality, the employee then also received his normal salary. But this is where it becomes more complex. On the 11th of May, the municipal council resolved to ratify the appointment of Mr. Monku for the period of 6 until 11 May 2021, so a period of 5 or 6 days. Further, the council resolved to appoint the administrator, who I referred to earlier, as an acting municipal manager effective from 12 May. So we have Mr. Monku, who's appointed only for 6 days, and then thereafter the administrator will then take the place as the acting municipal manager from 12 May. Now, a day before the appointment of Mr. Monku, when the appointment was ratified by the council, on 10 May, Mr. Monku, in his capacity as an acting municipal manager, advised the employee in this case that he has accepted his withdrawal of the resignation. So a municipal manager acting, who's only been in the position or only appointed for 5 or 6 days, now goes back to this employee and says, I'm accepting your withdrawal of your resignation. However, when the administrator, who received the original resignation and who rejected the withdrawal on the 15th of April, when he took over on the 12th of May, he instructed payroll to terminate the employee from the payroll of the municipality. So there was a dispute. Employer is saying, you are no longer an employee. Employee is saying, I am an employee because my resignation, the withdrawal thereof, was accepted or consented to. There was a dispute, and ultimately this dispute was then referred to the Labour Court, and that is what we are unpacking now, the decision of the Labour Court. So firstly, the court had to determine whether the employee had resigned, and secondly, the court had to determine if the employee resigned, was there consent to the withdrawal of the resignation. But in terms of the first question, was there a resignation, the court said that resignation as a voluntary act is a unilateral act that ends the employment relationship. The court said that the resignation takes effect once it is communicated to an employer, and it is incapable of being withdrawn unless the employer consents thereto. Now, in this regard, the employee argued that the administrator, the person who he handed his resignation to, is not the employer to whom the resignation must be communicated, and therefore the resignation did not take place. So on the first question, did a resignation take place? The employee said, I never resigned because I didn't resign to the correct person. The court rejected this argument because in practice we resign to our senior. You don't resign to the MD, the director, the owner of the business. You resign, you send your resignation letter to your line manager. And the court said there's no doubt that the administrator read the resignation letter, and having read it, communication to an employer has happened, and therefore the court said that the resignation was effective on 1 April, the day he sent his resignation letter. As I've mentioned earlier, if a resignation is incapable of being withdrawn unless the employer consents thereto. So therefore, The second question the court had to determine was whether the employer has consented to the withdrawal or not. The court held in this regard that it was common cause that on 15 April, the administrator, in his capacity as the municipal manager, did not consent to the withdrawal. Therefore, the employee was bound to leave the employ of the employer on 1 April. Remember, the employee resigned with immediate effect. But what about the alleged consent to the withdrawal by the acting municipal manager who was in office only for a few days? And in this regard, the court said that it was common cause that Mr. Monku represented the employer on 10 May. However, when Mr. Monku accepted or consented to the withdrawal of the resignation, the administrator already refused to consent to the withdrawal. So what happened with Mr. Monku then becomes irrelevant. The court held that when an employee withdraws a resignation, all it means is that such an employee is seeking to be rehired or re-employed. And the employee in this case said on his own version that he resigned on the 1st of April 2021. And this in simple terms means that the employer and employee relationship came to an end, and in this instance it ended on 1 April 2021. So in terms of the timing of the consent, the court held that the withdrawal must be made during the currency of the notice period for it to be consented to. So back to Mr. Monku, even if Mr. Monku could have a consent to the withdrawal, the court said for you to consent to the withdrawal, the withdrawal must take place, the consent must take place during the currency of the notice period. Mr. Monku only consented on the 10th of May, which was more than a week after the notice period expired. As mentioned earlier, the employee was paid in full after his resignation, and he argued that this shows that the withdrawal of his resignation was consented to. Again, this was rejected by the court. The court said that it may have happened that the employee was paid in error. So the court then concluded that it must be presumed that once the administrator received the resignation letter on 1 April, and having not objected immediately, he accepted the resignation. In any event, there is no legal requirement in our law that the resignation must be accepted by an employer. The only thing that would save the resignation is when the employer consents to the withdrawal, which, as we know, did not happen in this case. For all the reasons that I've mentioned now, the court then held that the employee resigned and he is no longer an employee of the municipality. So, what is the importance of this case? Number one, when an employee voluntarily elects to resign, that resignation cannot be unilaterally withdrawn once it has been communicated to the employer. The employer must consent to it. Number two, when an employee has failed to serve a notice period, this failure has no impact on the resignation. And then finally, number three, the only way to revive the contract of employment would be through a fresh offer and acceptance, which amounts to rehiring or re-employment. And this can occur if the employer opts to consent to the withdrawal of a resignation. Ladies and gentlemen, that then brings us to the end of this video. I hope you found it useful and insightful. I will see you in 2 weeks' time. Bye-bye.